Go from
Or
there.
is Rob coming?
He is coming. He's going to be a little bit late.
I
But we'll
know.
start
It
now.
sounds good. Actually, if this client calls me in like 15 minutes, I'm gonna have to drop, unfortunately.
Okay. All right. We are there now. So I wanted to introduce, this is George Pappas. He is a former immigration judge, excellent immigration judge, and also was formerly in private practice. And he also set up his own law school. So from there, I'm going to let George take it away and talk to us about what happened recently.
Thank you, Susan. I was a judge up until July 22nd of this year, just a few days ago. And I was, my location was in Chelmsford, Massachusetts. I was previously in Boston at the Boston Immigration Court. So for the past 2 years, I've been in New England hearing asylum cases, cases that deal with adjustment of status, cancellation of removal. I mean, those were the three main cases or types that I dealt with. And I probably closed over 2,000 cases, probably several hundred merit hearings, countless master hearings, motions. I probably ruled on over 2,000 motions. So the work never stopped. It was pretty intense. And I enjoyed the work. I enjoyed being on the bench. I enjoyed having my own court. And I can tell you, having 20 years of private practice experience in immigration, it really gave me not only an empathy for what the clients are going through, it gave me an empathy for what the attorneys needed to do. So I was in that attorney seat for 20 years. So that's good and that's bad because I could see who was doing their job and who wasn't. Um, it really became evident. And I would say I was surprised. I saw a lot of attorneys in the Boston area that were not prepared. I can't tell you how many times they did not prepare their clients for testimony. For example, they would testify and they would contradict their own declarations. It's like you didn't prepare your client to at least be consistent with what they put in writing. I mean, that's exactly what, the Department of Homeland Security is looking for is inconsistencies.
Okay.
So that was a preventable, mistake. They could have prepared those clients for, their testimony to at least be consistent with their own declaration. So the fact that that wasn't done uh, was pretty poor. But overall, I would say the attorneys are very good in Boston. I got along with the DHS attorneys. I'll tell you, every DHS attorney wanted me to stay. Not because I granted what they wanted, but because I was fair. And I would say the vast majority, I can't say everybody, but the vast majority of the private bar wanted me to stay. So I had a situation where the private bar and DHS were like in shock that I'm not on the bench. Uh, I'm not in shock because I was expecting it. But excuse me. But
What,
I was
what,
very disappointed. I was
why
very
were you,
disappointed.
why were you expecting it?
Well, starting in January, when Trump was inaugurated, within hours, he fired all of the leadership of the Executive Office of Immigration Review. He fired the acting director. He fired the chief immigration judge. He fired the general counsel for the OIR, and he fired some other person. So within hours, the leadership of EOIR was decapitated, and we knew that change was on its way. The dark clouds started to emerge. Shortly thereafter, he fired 13 judges in mass, about 13, one of which was in our courthouse. She was shadowing me to get trained to handle all the technology. And she was one of the top lawyers out of the Department of Homeland Security. Her name was Carrie Doyle. Maybe you remember the Doyle memo? That's her.
Yes.
Okay.
I
So
worked
Carrie
with
Doyle,
Carrie, I worked with Carrie when I used to be Department of Homeland Security Counsel, formerly INS, with Department of Justice in Boston. So,
so you
yeah,
know her. You know her.
yes.
So Carrie and 12 others were fired. They got 15 minutes notice to pack up and go. Uh, I didn't realize Carrie and I went to the same high school as your dad went to the same high school.
Yes,
We all went to a place called Northfield Mount Hermon School.
that is true.
Small world, very
It's
small
small
world.
world.
Anyway,
And
when they
as a
were
side
some of
note,
the
just a little side note, my grandfather worked security there as a state police officer on the side.
where at
Well,
NMH,
I actually not on the side. He eventually went there full time. Yes, Mount Hermon.
small,
Yeah.
wow, small world. Well, so I was expecting these firings because it started with Kerry's group. Then in April, um, About another 8 judges were fired nationwide, 3 from our court in Chelmsford, Mass. And the ones they fired were great judges. I mean, they were experienced, bright. I mean, I was in shock that they fired them. They did. By this point, the writing was on the wall. They're firing people who are on probationary status. We were considered the low hanging fruit because we weren't converted yet to full time employees. Normally, about 95% of a probationary group is converted. It's not a big issue. Um, what's emerged now is more than 50% of our group has been fired. So by the time we got to June, we had people that were resigning because the morale had plummeted because of the firings. Staff started to resign. Of course, the backlog's growing while this is all happening. And people basically said, this is the worst decision I ever made. So they took early retirement. Another person retired because there were no accommodations made for her for medical issues. Think about that. She had medical issues. She was asking for reasonable accommodations from EOIR. She got denied. She says, this is crazy. I'm out of here. She left. Then they
That's a,
fired it.
that's a violation of law too.
Of course it is. Um, then they fired a 20-year Navy veteran who was a judge in the Navy. 20-year veteran. We didn't think they would stoop that low and fire him. They fired him. This poor guy, he transferred out of the Navy, moved his family to New Hampshire, bought a home, put his kids in school, and they terminated him. And he's going to rebound, but he did not need to go through that. It was a real slap in the face for a veteran who was honorably serving our country. I was just mortified. By this point, we were just disgusted with the way we were being treated. People say, well, why did you stay until the end? I stayed because I wanted to write it out until the end. As long as I could do some good on the bench, I stayed. And I started calling the court, the Chelmsford Titanic. I said, I'm going to be there until the very end. I'm just looking for some lady to hug on the way down.
Why were you or any of these people fired? Was it for cause? I can't imagine it was for cause. You've just stated, and I know Carrie, and I know I'm sure the JAG attorney was amazing, and I know you. Why were you fired?
Well, we don't know why we were fired. We were not. Nobody was fired for cause. Normally, if you're not converted to full-time employment from your probationary status, it's because your performance was not acceptable. Maybe your temperament wasn't good. Maybe you didn't close out enough cases that you should have. There's a lot of performance targets that they could have identified as being sufficient to not convert a judge. None of that occurred. It was just a dismissal under Article 2 of the Constitution. And the Attorney General and the President said, we got the right to terminate you. We're going to do that. Your last day is July 22nd. You've got to the end of the day to hand in your equipment, and you'll be placed on administrative leave until so and so. So we were not fired for cause. Nobody was. Nobody ever has been for the last 6-7 months. All the firings have been arbitrary. And there is one group that is suing the government because of the way they were terminated. Certainly we're looking at that as well. Obviously we have to. So nobody knows why we were fired. However, the statistics and the empirical evidence now is emerging. We now know what kind of folks were retained and what kind of judges were fired. And here's what's emerged. I mean, there are small exceptions, but in the main, they have retained judges that were former DHS counsel. They have retained judges that were former state prosecutors. They have retained judges that were former attorneys with the Department of Homeland Security or ICE. They've even retained some attorneys, judges that had no experience with immigration at all. But on the other side, they have fired just about everybody, if not all of us, who are in private practice. They certainly went after people that did pro bono work with nonprofits that catered to immigrants, like me as well. And they also fired people that were veterans of the Board of Immigration of Appeals, staff attorneys. Most of them were also let go. So that's the group that was let go, and I was part of that group. So what emerges from that is an imputed political
Opinion.
opinion. They're imputing that we are liberal, that we're biased, that we're not going to follow their policy. They're imputing that, and the statistics are now supporting that. You couldn't really say that back in February, but you can certainly say that now. And we have another class that's up for their probation in September. So we expect more facts to underscore that. So that's why we believe we were fired, because of our imputed political ideology, which is really the only way that we can appeal this whole mess. That's the
Absolutely.
exception. So we're
I
going
have
to
a
look at.
question on that just to make sure I understood it right. So you could have been a probationary immigration judge, but if you had a DHS background as an attorney or a state prosecutor, you might have been retained, even though others that were probationary or right before their probation was to expire were let go.
Correct. It's exactly what happened. I'll give you an example. We had 4 judges whose probationary period ends. It ends after 2 years. So we had one group whose 2-year term was up in April of this year. And right at the end of their probationary period, 3 of the 4 were fired. The one that was retained was a former DHS lawyer. There's an example. And the other 3 were great attorneys. I mean, great judges, but they were fired summarily. They were gone. And so they retained her. Going forward, we have one judge that's a DHS veteran out of New York. I expect her to be retained in September. We had another judge this week who resigned with a military background. He had enough. He's leaving. The other judges that remain in Chelmsford are private practice. That person will be gone in a year or sooner. One is a Department of Justice Honors Program graduate. It's indeterminate as to what's going to happen. And the replacements for all of the judges that they fired or the judges that resigned, if they come in, they're not going to start trickling in until the fall. And they need another 2 years to get trained. So there's no way they're going to be able to manage the backlog. It's going to increase exponentially. It's going to go 2018. It'll be 2019. It's in total free fall. The backlog is in free fall. And so that's just our court. Our court and Chicago got hit really, really hard. Really hard. And our
Those
courts knew.
those just happen to be blue states. Is that just coincidence, or does that go about again on the imputed political opinion, targeting blue states, targeting people that they believe may be liberal minded or liberal minded because you're empathetic?
Well, what's ironic, you used the word empathetic. A memo came out just before I left, June 26th. I'll send you the memo. And this memo is so dark because the memo accuses certain judges in EOIR of having a bias, of imputing their political opinion into decisions. And the memo says, if you're doing that, we're going to fire you. And so what's going on with this memo? It's a threat that we think some of you are biased. It's a threat that we're going to fire you and we're watching you. And so it's dark because it goes back to Jeremy Bentham's utilitarian concept of how to set up a prison watchtower in the center of a circular prison where you always believe you're being watched. So all of a sudden, you've got self-censorship being imposed upon our judges on top of all of the other stress, the stress of handling the work, the stress of your colleagues being fired, the morale going down. And then on top of that, they throw out this memo to all the judges, adding another layer of stress because now they say, we're watching you. You make a mistake, we're going to fire you. Well, fairness and due process has always been there. That's our guiding star. To now say that some of us are not fair or promoting due process is saying, we're watching you. And so the judges have to figure out, am I making the right decision? Am I being fair enough? Is my ruling weak? Am I going to be fired? It's another layer of self-imposed stress through self-censorship. And that's the kind of toxic environment that is really hitting the entire core. It's another attempt to push out people. It increases the stress level,
Yeah.
and it's going to force some other people to say, I've had it. That's what they want people to do.
Because George, I think what they mean by that memo, and I bet you believe that. I mean, it's coming from this administration. When they're saying you're being biased, they mean you're not ruling the way we want. Because if you were biased against private attorneys and immigrants, constantly denying everything, even things that should be granted that fall within the perimeters of the law, I think that bias is okay to them. But bias in sense of their term bias, but within the parameters of the law and you're granting, isn't that what they're referring to maybe?
They could. One thing is clear, though. The memo masquerades as being promoting fairness and due process. That's the masquerade. That's the smokescreen. The subtle reality is what you described. Um, and I think they are accusing many who are not ruling in the way that they want. It's a strange way to tell people that. They're using the smokescreen of being fair and promoting due process. But by saying to folks in this memo, many of you are not, now they're really trying to lean and say, you're not ruling in the right way. What's the right way? What's the right way? I mean, the right way is protecting due process of fairness, but how you do that is a nuanced area. Each judge is assessed on their temperament, their performance, to see if they're doing just that. But to throw out a blanket memo to the entire EOIR and just accuse people of not doing this is really Orwellian. I think that's the word I want to use. Orwellian.
Well, would not be ruling the right way, not following the administration's policy to DHS, and this is the way we see the law. So you need to do what DHS is telling you to do.
Yeah. I'll send you that memo. It's really dark. To me, it's Exhibit A for the disingenuous approach by this administration. And it's Exhibit A for showing how pressure is being applied on judges to rule in a certain way, despite the rhetoric in the memo. That's how dark this memo is. And I just had a chance to really study it yesterday because I was on my way out by that point. But I'll get that memo to you. It's a really bad one. So, but again, the ultimate result is putting pressure, undue pressure on judges to do their job. It's another way of interfering with their performance. And it adds to the other factors that have been going on for the last 6 months. So you have this crescendo of toxicity poisoning the immigration courts. You also have to consider all the public memos that have been written since January 20th. Most of them are vindictive in their language. They're constantly taking shots at the previous administration, calling them unethical, illegal, unprofessional. They have a right to change policy. EOIR and the Department of Justice can change policy. But when you look at all these memos where they're changing policy, they're constantly taking shots at the previous regime. They're the bad guys. We're the good guys. They're the bad guys. We're the good guys. Totally unnecessary. And that tone also filters down through the court system. And that tone also is dark. It's just another example of how they're creating stress and fear just within the court system. And
Well,
so,
what's extremely dark about that, if I could just, is also that I used to work as during the Biden administration and under 4 or 5 different presidents prior to that, as an attorney, and I believe everything that I did was ethical. So if you're saying that the prior administration was unethical, are you calling every attorney for the Department of Homeland Security, every officer, every agent, every immigration judge unethical?
well, it certainly comes close to that. They're just casting a dark cloud on the previous regime, whoever you are, and they're saying the way they did it is wrong. And it's really horrible because you can see how policy and politics are being used both directly and through innuendo and indirectly to create an environment of fear, stress, all of which undercut the ability of a judge to function comfortably within a neutral zone. You cannot be a judge and having constantly to look over your shoulder to see whether you're doing the right thing. It is a huge encumbrance. The job's tough enough, to be fair. It's tough enough to do that. And then to have all this going on top of you, it makes the job virtually impossible. And people have asked me, well, George, if this was all going on, why did you stay? Why didn't you just leave? Well, from my perspective, the more stress they applied to the court, the more determined I was to stay in there. I was not going to be pushed out. I felt as long as I could do some good, I'll stay on that bench every single day. It was a form of resistance. My other form of resistance was cleaning out my entire office. There wasn't a picture or a frame on the wall. It was completely bare for 4 or 5 months. That was my silent protest to say this is not going to affect me. And I see
Oh, and
Mr.
welcome,
Ratliff has
Rob.
just entered.
Yeah.
Good
Hey,
morning.
Rob, this is
Hey,
George Pappas,
yeah,
former amazing
yes.
immigration judge. And
No,
I've,
okay.
I've asked a lot of questions. He's given a lot of information. You might want to ask him some questions because he's talking about the pressure that was put on immigration judges to um, pretty
Do their
much rule a
do their job.
certain way, right?
Yes, definitely in a certain way. Absolutely. But I'll let Robert ask some questions, and if we've already answered them, we'll just move on. But nice to meet you.
Yeah, nice to meet you as well. And that's we're certainly seeing that. And actually, I had to just finished a press conference on another case we're working on here. And I mean, I think even more so than being told to rule a separate way, I'd like to hear your opinion on it. I think judges are afraid to do anything that might be seen as independent or uncontrollable due to the current chaos in the system with terminations.
Well, that question you just raised was discussed just now between Susan and I will refer you to a memo, which is Exhibit A, but what you're concerned about. It was a memo. It was a public memo. I think it was dated June 26th from EOIR. And this memo threw a warning shot to all judges that said some of you are not doing the right thing. Some of you are not being fair. You may be imposing biased views into your rulings. And the memo is dark because now it is imposing self-censorship into the judge. They don't know whether they're doing the right thing or not. On top of all the other stresses that the judges have had to deal with, the firings without cause, the resignations, the toxic PM memos that have been written since January 20th. On top of all of that, and on top of the daily stress of just handling the backlog, you then have a memo like this, which is pouring gasoline onto a fire that's already burning. So the increased stress of imposing self-censorship is a form of abuse. It's a form of intimidation because these judges now have to figure out, well, I'm already trying to promote fairness and due process. Now what's the issue now? It's because they're imposing another layer of self-censorship. Now, what do I have to watch? How I rule? I have to watch the verbiage I use in my decisions. What is it that now could get me fired? So it's a warning shot. It's also, as Susan mentioned, a way to compel judges to perhaps rule in a certain way. And of course, that's undermining the entire court structure in terms of neutrality. But we don't need this memo to show you that EOIR has put pressure, direct and indirect, on judges to rule in a certain way. That's probably the most explosive thing you're going to get from a judge that just left EOIR. Where this has been paramount has been when ICE has been roaming the courthouses, as you know. And as you know, DHS attorneys will move to dismiss a case, and if the judge grants, more likely than not, as soon as the respondent leaves the courtroom, they're going to be handcuffed by ICE and taken into expedited removal and then shipped to God knows where. The key issue here is that judges, directly and indirectly, were told to grant those motions to dismiss. This is huge. This is huge because what it's saying is that the Executive Office of Immigration Review, whether subtly or directly, is aligning their policies with the government, DHS, and that destroys the entire court system right there. Different judges react differently. I didn't do that. I didn't grant any motions to dismiss while I'm in court. At the least, I'll give somebody 10 days to reply. If they had relief already filed, like a 589, there's no way I'm going to dismiss the case. If it was an initial master and they fear returning to their country, we'll give them an asylum application. we'll see you in 4 months, but if you don't file it in 4 months, you may be deported. But they have a chance. They have a chance, but they're not being summarily executed on the spot. So intimidation on judges is real. The private bar needs to understand that. And I think the private bar can integrate that concern in their hearings, because what you can say is that the arbitrary termination of judges shows that judges are not being based, or their performance is not being calculated in terms of how well they protect fairness and due process. If that's not being protected, how do we know that there's a fair court system here? You can preserve that argument for appeal later on. But it also puts the judge on notice. We know what's going on.
Yeah. And that's one of the things that I think is, and I think the general public doesn't understand the separation, between EOIR as a Department of Justice, uh, downwind of the Department of Justice and ran by the Department of Justice and at the discretion of the Attorney General, whereas DHS is an entirely separate department running USCIS and removal operations and controlling the government attorneys in the immigration courtroom. But it almost appears that the Attorney General's office through DOJ has abdicated their constitutional duties to adjudicate these cases and deferred to the interests of DHS. And I think that's a serious constitutional issue, because DHS has no constitutional role in immigration. That is specifically spelled out, that applies to the Attorney General.
Well, what I've done here is take away the curtain, pull back the curtain, so you can see how the sausage is really being created right now, and it's not a pleasant sight. Not a pleasant sight at all. What else? What else is on your mind in terms of immigration courts?
Well, can you ask him the question about the applicants for admission? Because I'm curious why they're all ruling against precedential case law.
Say that again.
Applicants for admission, they're all the judges are falling in line with DHS's argument, which is a flawed argument, ruling that applicants for admission can be anywhere in the country, including an overstay, a B2 overstay. And that way, by ruling that way, they can be picked up at any time under Section 235 as opposed to 236.
Correct. All right. This is a good question. Keep in mind that the MO by the White House is, we don't care if it's illegal. Just do it. If they want to take us to court, fine. It could be months, years before the court makes a decision. In the meantime, we get to implement our policy. We get to affect public perceptions. And so they're basically getting away with breaking law for an indefinite period of time. This fits right into that pattern. And the way this has evolved is, first you had an emphasis on apprehending people that were here under 2 years. And that's where the focus was initially with the motions to dismiss. So they would target respondents on the docket for that given day in a master hearing. They would target the ones that were under 2 years, and they would coordinate those motions with the assistant chief counsel attorney that was designated or appointed that day to be in the courtroom. And so they had a list of people they were targeting. DH attorney would then motion to dismiss, but those were targeting folks that were here for under 2 years. And so I won't go further into that. Now it's evolved even further. Now they're going after everybody who came in without inspection, and they're saying you're mandatorily detained. It doesn't matter that you've been here for 4 decades. We're going to put you into mandatory detention. Of course, they can still claim asylum hearings or whatever. But the violation there of, I'll call it due process, the opportunity to have a fair hearing, is draconian. So now they're going for the low-hanging fruit. They're going after everybody. It doesn't matter how long they've been here. And they're also saying you're mandatorily going to be detained, which means they're saying you're not eligible for a bond, which is absurd. They're relying on INA 235 instead of 236. There's some good case law out of Tacoma, Washington. I think you should I'll send you a copy of that federal district court case. So we have a very oppressive enforcement environment right now. It's going to get worse. Billions have been allocated to them. So enforcement's being supported. Justice is not. And anything that relates to justice is being defunded or given lip service in terms of support. And so we're moving closer and closer to an authoritarian state. That's the bottom line. So every single non-immigrant is now targeted by ICE where they can be found, whether it's at an interview at USCIS, whether they're showing up for court, whether it's in front of Home Depot. They're going after everybody. And of course, these agents are getting monetary bonuses if they meet their quotas. There's a horrendous monetary incentive to just forget about due process, arrest them, increase the numbers, and you'll be rewarded handsomely.
They're getting bonuses for real? That's a true thing?
Yep, this was on tape. I think it was a Texas apprehension, and the U.S. citizen who was caught up in the traffic stop was recording what the ICE officers were saying. So this is on tape. It made the news. So it's not.
I
It's not
saw a
private.
bunch of this, but I didn't finish the whole thing.
Yeah. So that's where that information comes from. But you're right. They're picking up people beyond the 2-year entry point. They're picking up people wherever they can, and they're putting in. They're claiming they're supposed to be mandatorily detained. Um, And what will happen as you have less and less judges is the backlog for detained cases will push out further and further and further. And they're hoping people will get so sick and tired of being locked up that they'll ask to be deported and removed. So they'll hope that they can wash out the population that way, just forcing people through stress to just deport themselves out of the jail. This is a horrific, horrific environment. I mean, look at the case with Garcia out of Maryland. The judge ruled withholding of removal. He granted withholding of removal. You cannot remove this person to El Salvador. You can remove him somewhere else, but not El Salvador. They just totally disregarded that. And then we're told by Bovey, they were telling the immigration director for immigration department at DOJ to lie in front of the federal court judge about what they were doing. That's why the whistleblower resigned. So the Department of Justice has been totally hijacked. It's no longer the Department of Justice. It's the Department of Injustice. They are running roughshod over the law, masquerading as officers of justice. But in terms of the immigration context, every single non-immigrant is fair game now. Everyone.
So with Rob's case, when he tells you about it, I wonder if that judge, I would think this is probably such high profile, that judge is being put under a lot of pressure to rule in accordance with the way the administration wants, or might be.
Well, that same judge, not knowing who that person is subject to all of the pressures that I've described. That's your default position. All the judges are working under undue pressure. The pressure of handling the backlog every day, preparing for the cases. That's your baseline stress. Then you've got the other stress knowing that your colleagues have been fired in mass. Then you've got these toxic memos on top of everything else. It's horrible. Their support staff is probably diminished, making it even harder for them. The other stress that they have to deal with, about 4 or 5 weeks ago, every judge in the country was told you can no longer reserve time to issue an oral decision. If you don't issue an oral decision at the hearing, you have to write one. There's no time to write there's no time to write decisions during the week. We're working full blast every single minute of the day. The only way you can write a decision is going to be on your own time on a weekend, which means a lot of judges, because they don't want to do that, they want to have a life, they're going to issue oral decisions which are flawed, which are weak, because they don't want to sit and write one. And it's going to make them more vulnerable to the BIA. But of course, the BIA has been decimated with massive firings as well. So the whole system is being totally corrupted. So the judge that's hearing your case is living in that world. The only issue now is what kind of judge is it? If you've been in front of them before, how do they rule it? I mean, if you don't know your judge at this point, it's really a disadvantage. Do you know the judge?
Do you know the judge, Rob?
Robert, have you?
Oh no, for our current pending case. Yeah.
Yes.
Yeah, no, we're in front of a judge. She's been on the bench for a while now, and normally is a fine judge. But I think we don't know. We do know that certainly there's a lot of intimidation for all judges across the board. So I'm sure she feels that, and that intimidation is, I think, is doubly effective with immigration judges because the stage of your career you're at when you accept this appointment and you undertake this. You've already built a solid career. You've already built a reputation in your field, and now you're risking losing all that to and starting all over again. So um, yeah, I mean, I think those are significant concerns in these cases, and the case that we're currently litigating, obviously it started even before it got to the judge. I mean, this started with a USCIS termination of an 8-year-old asylum grant or 7-year-old asylum grant. So there's a lot of DHS machinations going on in the background that that's my big concern is who is driving EOIR policy. Is it the Attorney General, or is it other agencies? And it certainly right now to me seems like it's other agencies with an entirely different agenda.
Bonding is not driving policy. Okay, you have to connect
Correct.
the dots, Robert. Connect the
Yep,
dots. It
I
starts
agree.
with Steve Miller in the White House. The
Yep.
next dot's going to be Assistant Attorney General McHenry. From McHenry, it's going to go to Cyrus Owen. Cyrus Owen is just the rubber stamp. Okay.
Oh,
Uh,
Siri, McHenry and Siri both came, and Siri, sorry, McSiri, Siri Owen, Cece, Owen. They both came from Atlanta. They were handpicked under Trump 1.0 via Tracy Short's relationship and working previously with the Atlanta office as a deputy chief counsel, and then he went to work for Sessions, knowing that he may be able to get pulled up. And so he was pulled up as the Office of Principal Legal Advisor, PLA, and then he pulled up his people. McHenry used to have a very good reputation. You could ask Jeremy McKinney, for example, the former AILA president. He really liked him, but he seemed to fall in line. But Cersei has always been somebody who is, I'm going to say it, evil.
well,
Because
Robert,
I've worked with, she did some not nice things in the Atlanta district to people.
she's not related to Alfie Owens, Susan, is she?
She's not. They actually, one is Owens and one is Owen.
Oh,
But I think she might be the one that Alfie Owens said was the bane of her existence. So that's saying a lot.
well, one thing has emerged here, Robert. Um, on the um, on the front end, not in your closing argument, but in your opening argument, you are advised to question the efficacy and fairness of the court before the hearing starts. You need to identify the facts that I mentioned as evidence of how the judges and the courts are being stressed and pressured to rule in certain ways. And I think putting that on the record, I did that also as a private attorney when it wasn't as bad.
Yep.
I did that in Philadelphia for 42B, but I did it to preserve it for appeal later on, because if you don't raise it, you can't raise it later on. So put the judge on notice that you're aware of what they're dealing with indirectly. Put the court on notice that you don't think it's a fair hearing by what's been happening, and then you can argue why your client merits, as a basis of discretion, a favorable ruling in the hearing. And then you go through your regular evidence. But if you don't put that in there, you've really closed off one avenue for appeal in case the decision goes against you. It also puts counterweight on the judge. It puts her on notice that, whoops, these guys know what we're going through. They also know about these memos. And it'll somewhat swing the pendulum back toward you a little bit, toward fairness. So I think it's a good approach to use. You'll have to craft your own wording, but you have more than enough evidence now to show that due process and fairness is under assault at EOIR. You've got that now.
Yeah, yeah. I think they've put it in writing as much as they can without being explicitly just do what we tell you.
Of course, my public pronouncements can be used as evidence. I'm a former judge. I'm the whistleblower. I'm all over the press on this. And not just me. It's Judge Payton out of Chicago. It's Judge Ida Weiss out of San Francisco. You've got more than enough judges that are corroborating what I just told you.
Yeah.
And the ACIJ out of Chicago said, what did she say to you? That they were being told to pressure you all?
Yeah, they got a memo putting pressure on us to grant those motions to dismiss. That came out in a CBS interview a week ago when she was sitting next to me. I suggest you go back to that interview on July the 23rd, I believe. It was a Wednesday night. CBS Evening News. You may want to review that interview.
Yeah.
So it's a different landscape. It's a toxic landscape. Immigration is, in my opinion, morphing into a very dark place. And I basically have connected the dots where I think they're, in the short term, they're cleaning house with every possible judge that they don't want in there, either through pressure or through terminations. Eventually, they'll hire their yes men to replace us. And so that'll create somewhat of a coherence in terms of being able to control all the judges. It's not going to affect the backlog. It's totally in free fall. They could care less about the backlog. So the backlog's a horrendous problem, which means they're not really interested in saving the court system. Anything they can do to destroy it, I think they're doing a good job of it. So I think what will happen eventually is the court system will be dismantled. Enforcement will fall under DHS. You'll have immigration officers, and the entire swing of immigration adjudication is going to swing toward the detained docket. That's why you're seeing a lot of pressure on being able to detain anybody now. Get them into a detained environment, and let's try to stop all these non-detained hearings. This is the Orwellian roadmap that I see happening here. As long as these folks stay in power, that's the trend that I see. Less due process, less court proceedings, more detained dockets, more administrative officers making judges with decisions on asylum and so forth. The whole thing is just collapsing in front of our eyes. And that's just the immigration court system. I'm not talking about what else is happening between universities, healthcare, food stamps, you name it.
So if
But
they take away due process from immigrants like this, which it feels, I have felt this year with judges, that's not a fair proceeding. Especially because again, I was with DHS and Legacy INS as an attorney for 26 years. And I already knew the feeling of what it was like to be on the government side and generally get the benefit of the doubt from most judges, not all judges, depending on the judge. Sometimes you'd actually be on the other side of a judge where you weren't perceived to be, you have to prove your integrity to the court, because they might have been biased against DHS. But most of them, you had this leg up in most of the courts because you were government. But now I feel that they've really given the government everything. Now, going back to where my question was, which I'm losing my train of thought, sorry, was how is this going to play into if I have to go to court eventually in systems that might be controlled like this eventually as a U.S. citizen? Do you feel like this could possibly start also becoming practice in whatever courts, especially if they're administrative, like the Merit System Protection Board, for example, anything that falls within the parameter of the executive branch being able to control it?
well, now attorney generals have been fired. The Merit System Protection Board has been denuded, so it doesn't have a quorum. That's the bad news with the MSPB. The good news is now you can go to district court with your claim. You don't have to go through MSPB because there's no quorum. But overall, what's happening is the guardrails that were under the executive branch are being either dismantled or undermined. So any kind of due process there is being dismantled. I think U.S. citizens should be really concerned because their due process, their civil liberties, are under threat right now, and it's going to get worse. If the government is allowed to dismantle due process here, it's just a short step away from filling detention beds with U.S. citizens at a protest, arbitrarily being arrested. I mean, they're already being arrested, U.S. citizens, without probable cause. So it's happening. It hasn't happened in mass, but it is happening. This is why U.S. citizens really need to wake up and say, well, we're next. If we say something, and of course, the fear factor is going to permeate through society. There's going to be self censorship everywhere. Look at the media chains. They're buckling. They're paying all these ransoms. ABC, 15 million to Trump. CBS, another 16 million to be quiet. Columbia, 200 million. Harvard is ready to pay 500 million. They're all paying the ransom to sort of exist. These strong arm tactics are going after our institutions. Once you destroy our institutions, we don't have a society left that we know as a democracy. So our institutions right now are under assault. The immigration courts are just part and parcel of the assault. Um, it's an American problem. It's not an immigration problem. We're part of that problem right now, and people have to realize you're not going to get your food stamps if you need food. You're going to lose health care if you have Medicare. A lot of you, millions, are going to lose that. Your university, they're going to be denuded. They may not be able to recruit international students, which used to pay the full freight without financial aid. So university staffs are going to be cut, jobs are going to be lost, and they're going to be strung on into what to teach and how to say it. It's already happening in Florida. Uh, so these assaults are a direct assault on our way of life. And until people wake up and realize that their way of life is under attack right now, um, it'll be too late for them when it starts to really hurt, unfortunately. And these are really dark times. I'm happy coming out of the immigration side to let people know what's happening with judges, due process, and fairness, the assaults that we face. I think we have an important platform and privileged to have this opportunity to speak to the press, and I'm taking advantage of it, and other judges are. We are not disappearing quietly into the wilderness here. We are very loud about what's happening. It's basically the canary in the coal mine. We're telling you it's happening now. There you go.
Rob, I have one
So,
more question to help for you because I'm curious.
Yeah.
So, if a former, if a group that is no longer declared a terrorist group, like Muslim Brotherhood, which is no longer on the state-sponsored terrorist list, it was taken off during the Obama administration, and I believe that had to go through congressional hearings in order to take it off, but it definitely went, of course, through the State Department. And they were taken off, but now I believe in Rob's case, they're being considered, the government is trying to argue material support to some other charity that really did charity work, to the Muslim Brotherhood that also does charity work and is not a state-sponsored terrorist group. Um, they're trying to argue now, the government, which I find a fallible argument because I couldn't ethically argue that it's a terrorist group when it's not on the State Department's list anymore. But they're being told to argue that that's a terrorist group and that his client helped sponsor them, right? Sponsor them?
I,
Not sponsor them, yeah, money.
Yeah, and I think the biggest, the tier three designation, by statute, it allows an asylum officer to make that terrorist group designation on a case by case basis, um, you know, with ample review and all that. But what we have here is we have one asylum officer and now DHS OPLA attorneys arguing not on a case by case basis, but saying unequivocally Muslim Brotherhood is a terrorist organization. That's it. So, first, that's not within their purview. I mean, that's a State Department issue and an administrative issue, but, um, you know, it certainly appears that Department of Homeland Security is running most of the government at this point. Um, so, I mean, that's the first issue, that they've made this broad, sweeping allegation regarding Muslim Brotherhood. But then they followed that assumption with no factual findings. I mean, there's no specific factual findings. They followed that up with the fact that our client worked for a local branch of a national charitable organization, and he served as a board member of his local group, much like Kiwanis or Rotary, where we've all been involved in probably. So they then inferred that based on his local participation, he was aware of what the national group was doing, And because of that, he was aware that maybe some other local branches were participating directly with Muslim Brotherhood in providing charitable services. And because of that, the entire national organization is guilty of providing material support to Muslim Brotherhood. Therefore, he's guilty of providing material support to his organization, and three steps down the road. And that's not only is that all kinds of logical fallacies and assumptions and other issues with that. That is something that's being made retroactively now against an asylum that was granted in 2018. So, and as I point out to a number of people, that means nowhere ever is any asylee ever safe in the United States. As political winds change, no, we're going to go terminate, and we're going to detain you while you adjudicate whether or not our termination was appropriate.
This is a chaplain at the Children's Hospital in Cleveland. A lot of riots over it. I mean, not riots, I should say, peaceful protests over his incarceration and lack of due process.
Yeah. Yeah, there's been a lot of public support for him, and we'll continue to fight. I mean, obviously our our focus right now is on the APA action, the Administrative Procedures Act action down in district court, and we hope that federal district judge and the U.S. Attorney's Office will have the independence necessary to look at this as it should be looked at.
District court, district court, so you're in a better place right there, hopefully.
Yeah.
And the
Would you
government
rule
has
that that's, would you rule that that's sponsored, that he's giving money to a terrorist organization in that case, if they're not on the State Department's terror list, and it's so disingenuous. I mean, I can't think of the word, but it's definitely a flawed argument. It's definitely disingenuous to say that because you gave to the Red Cross and the Red Cross turned around and gave to another form of the Red Cross, if one little part of the Red Cross is doing something you don't like, that somehow he must have known it and he must have sponsored it.
government's going to have a huge burden to prove all that. Good luck with that. I don't think they have a leg to stand on. It's just a form of intimidation. That's what this is boiling down to. When you get down to evidence, I can't see how this is going to stand up to scrutiny. But in the meantime, you're going through all of this upheaval, detention, money for litigation, filing claims. I mean, that's all. And he's sitting in a jail cell somewhere. So
Yeah.
it's really,
And we had pursued bond in immigration court, but the immigration judge just ruled that no jurisdiction for bond due to the material support allegations, which are not contained within the I-261, the amended NTA. So we'll see.
I didn't handle the detained docket, so I'm not up to speed on all the bond motions. Especially,
You know what, George, it wouldn't matter these days because they're not ruling in accordance with the law.
Yeah. Well, and Susan, you brought up an interesting analogy with the Red Cross. I mean, tons of us donate to the Red Cross anytime there's an incident or fire in your neighborhood or whatever. But let's not look too closely at the Red Cross and their involvement in World War II in Germany. So at what stage do we stop looking to past entanglements? Do we?
I don't think it'll get past district court. And I mean, when was the claim filed with district court? When did you file?
The APA action was just filed late last week. So
I'd be interested. I'm finding that they're using matters. This administration started ordering, and I'd be interested to find out if it happens to you, Rob. They started ordering magistrates to kind of run interference to slow everything down, basically claiming you don't have a claim when it's clear you do. I mean, I have I have some APA violations out there that are clear. I mean, I've won them before everywhere. But um, some of the courts, like North Carolina did this recently too, are putting them, even after the case has already been there, they have a magistrate going back and reviewing it again and then trying to kick it out. And then just, even after you respond, it just sits there. So you almost have another APA violation against the Department of Justice itself.
Just go with the 12B motion to dismiss and just force them to fess up what they got right now. Just go in there with a motion to dismiss and knock it out. I think you have a good shot doing that.
Yeah, or,
Thank you.
it's not a bad idea. We're I'm filing a supplement today on the emergency TRO to try to get him released now that the immigration judge has declined jurisdiction. So yeah,
Well, good luck with that one. Good luck.
yeah, thank you.
That's Exhibit A for the kind of harassment that you're seeing. That's out there.
Yeah.
That's Exhibit
Well,
A.
I may go back. It's not a bad suggestion. I may go back and include those policy memos as an exhibit.
Yep.
Yeah.
Good.
Well, Mr. Pappas, thank you very much. I appreciate your time.
Well, thank you, sir. I appreciate your podcast. Susan, thank you for inviting me and your support.
You're welcome.
And keep up the good work with the podcast. Get the message out there and get the right folks in front of your microphone and get the word out. Good job.
Yeah.
Absolutely. Thank you. And maybe we can, if you talk to your other colleagues, we can have them on as well to hear their perspective.
All right. Where can we see the podcast? You let me know, okay?
We upload it on Spotify, and there are links on the website that needs updated, of course, like every website. It's just theimmigrationpodcast.com and the Immigration Podcast on Spotify. And I upload it to my YouTube channel as well, Rob Ratliff, immigration attorney. And Susan, I don't know where you're uploading it at, but
I need to upload it there. I've promoted it on Instagram and TikTok, and I think I haven't yet on Facebook, but I will.
Spread it out. Spread the word out.
I will be spreading it out, and
Yep.
then also, I'll probably put it on my Facebook page. I mean, my YouTube page as well.
Well, you guys raised
Yep.
a lot of good questions here. The issues are real. They're not abstract anymore. So everything we're talking about is happening on the ground. So I'm glad I had a chance to give my 2 cents about what my experience has witnessed. So we'll take it from there. Thank you, Robert.
Thank you.
Thank
Yep.
you.
hey, I appreciate it. Thanks, guys.
All right, I'm going to sign off. Thank you.
Me too.
We'll see you. Bye.